Okay, para sa ating week 2 na topics, we're going to discuss, or I'm going to discuss to you the nature of probation in the Philippines. So, sa topic na to, madidiscuss natin or we will be able to justify the importance of probation as well as the concept and the philosophy of probation and the elements and the characteristic of probation. So first, for our introduction, so most of the correctional authorities believe that probation is the or one of the most effective and economical tools with regards to the or for the care and treatment and for the rehabilitation of certain adult and especially those juvenile delinquents offenders na nakakommit ng crime against the law. So that is the probation. So one of the most or the most effective and economical tools that we have, lalo na dito sa Pilipinas. So, wherein the convicted offender, yung kanyang sentence is temporarily suspended and he is permitted to remain in the community subject to the control of the court and under the supervision and guidance of a probation officer. So, yan yung kanyang pinaka-konsepto on how will we going to define or paano ba tumatakbo yung probation or ano ba yung essence ng probation. Again, ang main point is that yung probation, sinususpend niya temporarily kung ano yung sentence na nabigay kay convicted offender and he is permitted now para bumalik sa community but hindi ibig sabihin nun na siya is totally laya na. Sabi dyan, he is subjected or subject to the control of the court. So, under pa rin siya ng jurisdiction ng court kung saan siya kung saan nag-try yung kanyang case and under the supervision and guidance of a probation officer. So, mas mapapalawak pa natin na mamaya. Next, it says that probation is a privilege granted by the court to a person convicted of a crime or criminal offense to remain with the community instead of actually going to prison. Ito yung sinasabi natin kanina. But, the thing here is that sabi dito, ang probation daw is a privilege. Hindi natin pwedeng sabihin na yung probation program is a matter of right na lahat ng convicted offenders is meron silang right para ma-enjoy yung ganitong klaseng program. So no, it is a privilege. So meaning to say, pili lang yung mga possible na mabigyan ng ganitong klaseng probation program. So, nakadepende yan kung ikaw man ay maging qualified or kaya naman disqualified ka. So, depende pa yan kung pasok ka dun sa mga qualification and so on. So, madidiscuss din natin yan sa mga susunod na topic natin. In short, ang probation, again, hindi yan right, hindi yan karapatan ng lahat ng convicted offenders, but a privilege na binibigay dun sa mga convicted offenders na pasado dun sa qualification na pwedeng bigyan ng probation. So, next, the PD number 968 or the PD 968, otherwise known as the Probation Law of 1976, recognizes such trend. So, the main law until today, hanggang ngayon, governing the system and the policy, concerning the probation system, ang nangangalaga po doon or yung law that covering the probation program is the PD 968. So, however, the decree separates adult probation from juvenile probation, for it expressly exclude those entitled to the benefits under the provision of the PD 603 known as the Child and Youth Welfare Code and the similar law. So, ang ibig sabihin lang dyan, so mapapalawak pa natin yan sa susunod pa, that yung PD 968, siya yung nag-separate din kasi ang juvenile delinquent natin o yung mga bata natin or those minors na nakakommit ng crime is subjected din sila or may privilege din sila na mabigyan or mag-grant ng probation wherein hindi nila kailangang makulong kapalit ng kanilang kasalanang nagawa. So, kapag bata or juvenile yung ating ang ating involved. So, meron tayong PD or separate na PD, which is the PD 603, also known as the Child and Youth Welfare Code and the similar laws. So, yung mga laws na yan, pag-uusapan pa natin sa susunod na topic natin. But, the thing here is that, again, the main law na nangangalaga or that governing the system and the policy with regards to the probation system is the PD 968. Next, statements of the principles, goals, and objectives of the probation law are found in its preamble, and the preamble indicates 6 essential goals to wit. First is an enlightened and humane correctional system. So, bakit sinabi dyan na an enlightened and more humane correctional system? When we say more enlightened, di ba, as compared to the institutional correction, kung ikaw ay mabibigyan or ikaw ay mapapasailalim ng probation program, di ba, mas may direksyon ka sa buhay mo. Kumbaga, under ka ng supervision of your probation officer, meron kang kondisyon na sinusunod, so ibig sabihin, may direksyon ka na sinusunod, na patungo dun sa pagbabago mo for your reformation and for your rehabilitation. So, meron kang means of direction or meron kang sense of direction sa buhay mo while nagsiserve ka ng sentence mo outside the correctional institution. So, meron ka ring chance outside the institutional correction, na ma-enlightened ang iyong isip na merong chance na binigay sa'yo. So, grab the opportunity para magbago ka. So, ibig sabihin lang dito, lalawak yung pag-iisip mo, mas marirealize mo yung importansya ng buhay kasi nabigyan ka ng pagkakataon na makalaya at hindi makulong. So, next, and humane correctional system, bakit mas humane or yung sinasabi natin na mas makatao? Kasi kung ikukumpara nga naman natin dun sa mga taong nakulong inside the correctional facilities, na-deprive sila ng kanilang freedom. Unlike you, for example, ikaw ay under ng probation program, hindi ka na-deprive of your freedom or liberty. So, may chance ka, di ba, na mapagpatuloy mo yung buhay sa labas. Kung ikukumpara natin dun sa mga nakakulong, na nandun lang sila hanggang matapos yung kanilang pag-serve ng sentence. So, yun po yung pang-una. Pangalawa, the reformation of the offender. So, ang main focus din naman, same as with kapag ang mga offenders natin is under ng institutional correction o yung mga kinukulong nating offenders, ganun din naman. Ang focus din naman under ng probation program is for the reformation or the rehabilitation of the offenders para mapagbago natin sila at maging for the self-betterment nila. Yun naman yung focus natin. Aside from the nagsiserve yung dalawang yon, it's either makulong ka or nasa labas ka pero under ka ng restricted ka or under ka ng condition ng court, maalin lang doon, ang focus naman ng mga programs noon is to reform or to rehabilitate you or the offenders. Next, the reduction of the incidence of recidivism. So, ano ba yung recidivism na tinatawag natin? Ito po yung tendency of a convicted offender or yung nasintensyahan na offender to re-offend or to commit a crime ulit. So, pagiging habitual offender mo o yung pag-ulit-ulit mong pag-commit ng crime. So, bakit mo nasabi na maiiwasan yung pagiging recidivism? Ma'am, nakalaya nga sa labas. So, di ba po the question is, di ba po mas delikado kasi nasa labas siya? So, mas malaki yung possibility na siya ay gumawa ulit ng krimen. So, no. Kasi, ang subject naman to probation program, iyon naman ay yung karaniwan na mga kriminal na nakagawa lang ng krimen, di ba? That is, for example, first-time offenders, by accident lang yung pagkakagawa or under ng mga uncontrollable circumstances na kung saan hindi ka talaga totally yung criminal mo, I mean yung mind mo is criminal. So, ang ibig sabihin lang dito, kapag nasa labas ka na, so, ang cargo mo yung sarili mo. 'Di ba? Alam mo yung dapat mong gawin, under ka ng kondisyon ng korte, susunod ka kung gusto mo talagang makalaya or totally hindi na bumalik sa kulungan. Not unlike na nasa loob ka, ikaw ay exposed pa dun sa mga kapwa mo kriminal, mga hardened criminals na possible na mas makahawa sa'yo at maging cause pa for your recidivism. Sa halip na matulungan ka na ma-reform, matulungan ka na ma-rehabilitate. So kapag nasa labas ka, 'di ba, mababawasan or yung the reduction of incidence of recidivism is much higher. Okay, next. To extend to offenders individualized and community-based treatment program instead of imprisonment. So, again, di ba nga pag under ka ng probation law or ikaw ay nag-grant ng probation program, so hindi ka naman talaga, totally sabi nga natin, hindi ka makukulong. So, mag-serve ka ng sentence outside the prison, outside the jail, under the condition that na inimpose ng court sa'yo and then under the supervision of your probation officer. So, sabi dito, extend to offenders individualized and community-based treatment program. So, instead nga naman na maput ka to jail, di ba, to prison, at yung treatment na ma-receive mo is a mass treatment. When we say mass treatment, kung ano yung treatment sa katabing selda or katabi mong inmate or kasama mong inmate sa isang selda, same lang din yung treatment nyo sa lahat. Kung magdudusa siya, magdudusa ka. Kung magugutom kayo, magugutom kayong lahat. Kung hindi kayo matututukan sa inyong mental health, lahat kayo hindi matututukan. Same as with the other aspect ng buhay mo. Not unlike dun sa ikaw ay nagrantan ng probation program, nasa labas ka ng kulungan, minomonitor ka ng probation officer mo, di ba? May conditions kang sinusunod, so may direksyon ng buhay mo, and then may officer ka nga na nagmo-monitor and nagsusupervise sa'yo kung yung mga kondisyon ba na binigay sa'yo or yung mga kondisyon ba na pwedeng ibaba sa'yo ng korte is makakatulong, di ba? Para mas mapagbuti ka. Kasi nga naman, yung condition naman na binababa ng korte sa'yo, di ba, na dapat mong sindin, ay nakabase naman yun on your background or nakabase naman yun sa background ng nabigyan ng probation. Siyempre, di ba, nakadepende yun sa capability niya, nakadepende yun sa background niya, kung saan siya mas dapat tutukan, di ba? So, and by your own, di ba, ikaw mismo yung nabigyan ng probation, mas natutulungan mo yung sarili mo. Kaysa na-expose ka doon, kaysa makasama mo yung mga kapwa mo kriminal na pwede pang mas makahawa sa'yo. So, kapag again, ikaw ay nasa labas, under ng probation program, ikaw ay subject to individualized treatment. Next. It is limited only to offenders who are likely to respond to probation favorably. So, of course. Next. It is economical or less costly than confinement to prisons and other institutions with rehabilitation program. So, totoo naman. This is on the part of the government. Diba? Less costly. Sa halip na ikaw ay dagdag sa gustusin inside the institution, diba? Nasa labas ka na, diba? Mas makakakain ka pa ng mas maayos, bawasan ka pa dun sa gagastusan ng gobyerno inside the institution. Aside from that, so ikaw, kung nabigyan ka ng chance na lumabas or makalaya under ng probation program, hindi mabe-deprive yung family mo dun sa pangangailangan nila. So, mas makakatulong ka pa under ng probation program. Okay, next. Again, the PD 968 or the Probation Law of 1976. So, etong law na to or tong PD na to was signed into law by our late President Ferdinand E. Marcos on July 24, 1976. So, ano ba tong PD 968 na to? Ano ba ulit to? It is the main law until today, hanggang ngayon, that is governing the system and the policy concerning, the probation system. So, meaning to say, the PD 968, yan yung pinaka-main law na nagpapatupad ng probation system or program na meron tayo dito sa Pilipinas. So, next. The court may, after it shall have convicted and sentenced an accused, and upon application of said accused, suspend the execution of said sentence, and place the accused on probation for such period and upon such terms and conditions as it may be deemed best. So, ano ba yung focus muna ng PD 968 before natin i-discuss to? Yung nabanggit din natin kanina. Yung pinaka-main reason why na-create so PD 968, kasi bago to ma-create, meron pang mga unang laws with regards or pertaining to the aim na magkaroon ng less costly, diba? Less costly alternative dun sa imprisonment na meron tayo. So, again, ang PD 968, before yan ma-create, marami din tayong laws, or meron tayong mga batas din na na-enact din, na napaltan due to some problems or the irregularity sa batas. So, madidiscuss din natin yan na kung saan ang focus lang naman nila is magkaroon ng less costly alternative to imprisonment na kesyo nga naman na ilagay natin sila sa kulungan, isip tayo ng programa na kung saan mas makakatulong lalo na dun sa mga first time offenders natin, di ba? At the same time, magiging less costly sila on the part of the government. So, next, again, the court may, after it shall have convicted and sentenced an accused. So, ang ipinag-uusapan natin dito, di ba? Ang korte po, di ba? Ang part naman ng court sa ating PCJS or the function of the court pillar, sila yung nagbibigay ng judgment dun sa ating mga defendant. So, now, di ba, the court, kapag na-convict na or nabigyan na ng sentensya, yung akusado, now, upon application of the said accused, application meaning to say, ang probation law, hindi mo yan ma-enjoy, sabi ko nga kanina, hindi yan right, hindi mo yan ma-enjoy kung hindi ka magpe-petition or hindi ka mag-a-apply. Pero, again, yan po is meron tayong qualification na kung saan sila lang yung pwedeng mag-petition or sila lang yung pwedeng mag-apply to avail the privileges na meron ang probation law. Again, dahil ang court po ang nagbibigay or sila yung nagbibigay ng final judgment. So, once na convicted na si accused and then nabigyan na ng sentensya, so kung siya ay sakop ng probation law, mag-a-apply siya, magpe-petition siya. So, now, kapag nag-grant ni court o nabigyan ni court ng probation program, or nag-grant yung kanyang request or yung kanyang petition for the probation, so, isususpend ni court yung execution of the said sentence and then place the accused on probation for such period and upon such terms and condition as it may be, or as it may deem best. So, si court, binigyan na ng final judgment, convicted si accused, binigyan ng sentensya, and then nag-apply si accused, nabigyan ng probation. So now, nung nabigyan ng probation, sinuspend ni court yung execution ng sentence, and now, after the suspension, hindi ibig sabihin na nalaya na siya. So, lalaya siya, but subject to the terms and condition that imposed din by the court. So, ibig sabihin, si court yung nagbigay ng sentence sa kanya, si court din yung magbibigay ng terms and conditions kung ano yung magiging probation program na dapat niyang sundin. Again, the probation law is for the first time offenders. So, generally, it is for the first time offenders wherein sila ay binibigyan ng second chance to maintain their place in the society. Na kung saan, through this process, ito is a form of reformation na kung saan mas better to, diba? Mas ma-achieve ng mas maayos yung reformation na sinasabi natin kapag hindi natin sila hinalo o hindi natin sila nilagay sa kulungan, diba? Kasama ng mga kriminal. Diba? It is better to put them outside the jail, diba? Na kung saan yung mga binanggit natin kanina, merong individualized treatment, hindi sila ma-expose sa mga hardened criminal. So, mas malaki yung chances, diba, na magkaroon sila ng mas pinaganda at mas pinabagong buhay, not unlike dun sa proseso nung institutional correction na kung saan ilalagay ka sa kulungan, di ba? At makakasama mo yung mga tao na kapwa mo, kriminal, na minsan mas malala pa sa'yo, di ba? Bakit kasi first time offenders? Kasi sila yung karaniwan na nakagawa lang ng krimen by accident, di ba? Nakagawa lang ng krimen through uncontrollable circumstances, di ba? Na kung saan hindi naman totally yung nasa isip nila is criminal, meron silang criminal mind na kasing lala ng mga ibang criminal na nasa kulungan. So, kung sila ay nasa labas, di ba? Mahihiwalay sila dun sa mga kriminal na malala at mas makakakilos pa sila at makakagawa or makakapag-provide ng kanilang mga family needs, di ba? Instead na sila ay mas mapalala inside the correctional institution. So, yun po yung pinaka-purpose kung bakit na-create tong PD 968. Okay, probation define. So, first, the probation is from the Latin word probation, meaning testing, and it is also came from or originated from the Latin verb probare, meaning to, which means to prove. So now, what is the definition of the probation under ng PD 968? So how the law defines the the probation term. So it is a disposition under which a defendant after conviction and sentence is released subject to the conditions imposed by the court and to the supervision of the probation officer. So the probation is a condition, di ba? Or it is a state wherein si defendant, so wag kakalimutan, si defendant, ang tawag sa ating the criminal or yung tawag or specific term sa ating accused kapag siya is nasa court pillar na is defendant. So, kapag siya ay nasa prosecution pillar, di ba, siya is si respondent. And then, kapag siya is nasa correction pillar na, siya is si convicted offender or si person deprived of liberty. So, balik tayo. So, si probation po, again, is a condition or disposition under which a defendant, after conviction and sentence, is released subject to the condition imposed by the court and to the supervision of the probation officer. So, based sa definition, magigets nyo na kung paano ba tatakbo si probation. Ano ba talaga si probation? Yung kanina lang din diniscuss natin. It is a condition wherein si defendant natin, di ba, habang siya is nasa court pillar pa, ongoing yung trial, and then magkakaroon na ng final judgment, and then after conviction, so siya is convicted, di ba, binigyan ng sentensya, after conviction and sentence, is released, but i-release siya subject to the conditions imposed by the court, di ba? Si court yung nagbigay ng final judgment, si court yung nagbigay ng sentence, si court din yung magbibigay ng conditions mo or conditions sa'yo kapag ikaw ay nabigyan ng probation. At ikaw ay subject of course also, you will be under also to the supervision of a probation officer. So, ganyan yung magiging takbo ng probation program once na ikaw ay mabigyan. Nasentensyahan ka, convicted ka, i-release ka, pero again, subject ka dun sa conditions imposed by the court. At, of course, may magmo-monitor at may magsusupervise sa'yo, which is your probation officer. Next, for the concept and philosophy of probation. First, the concept of probation. Himay-himayin lang din natin to. The court convicts and sentences the defendant, but the execution of sentence, whether it imposes a fine or a term of imprisonment, is suspended and the defendant is released on probation. So again, The court convicts and sentences the defendant. So, matik naman, si korte yung nagbibigay ng final judgment and siya yung nagbibigay ng sentence. But the execution of sentence, di ba, is sinususpende, di ba, and the defendant is nire-release on probation, but subject to the conditions again imposed by the court. Again, the general concept or yung idea ni probation, si korte, siya yung nagko-convict, nagbibigay ng sentence kay defendant, but yung execution ng sentence na binigay sa kanya, masususpend yan. It's either yan man ay by term of imprisonment, yung pagkakakulong niya, or whether it is only a fine, diba? Mapa-fine man yan or ikukulong ka inside, yan ay masususpende once na ikaw ay mabigyan ng probation. And the defendant nga is released on probation once na ikaw ay nabigyan ng probation. Next, probation implies that during the period of time fixed by the court, the defendant is provided with individualized community-based treatment, including conditions he is required by the court. Yung sinasabi nga natin kanina na ang focus nga ng probation is para makapag-provide tayo ng much individualized community-based treatment as compare to the treatment na meron sa kulungan wherein ang nangyayari is mass treatment. Kung ano yung treatment mo or ano yung treatment kay number 1, dun sa lahat ng nakakulong doon up to 1,000 man yan, ganun din yung treatment sa kanya. Kung gutom siya, gutom ka. Kung walang program para sa iyo, walang program para sa kanya, 'di ba? Kung hindi mabigyan ng hindi ma-cater yung physical needs or psychological, mental or yung health nung needs nung mga convicted offenders inside the jail, ganun din yung meron ka. Yun din yung mararanasan mo. That is why yung tinatawag natin is mass treatment. Kung nagdudusa ka. I am pertaining to the negative factors kung ikaw ay makukulong. Pero marami naman tayong mga programs na kung saan yung mass treatment na i-enjoy din naman nila. But, sabi nga natin, mas malaki yung gastos ng gobyerno dyan. Kaya naman minsan hindi rin natututukan with regards to the education, di ba? Sa ibang mga programs na sila yung mag-benefit, hindi rin naman ganun gana natututukan. The point now is that instead na ikaw ay ikulong at maranasan mo yung mass treatment na meron sila, you will enjoy the individualized treatment or yung community-based treatment na pwedeng ilatag sa'yo na kung saan hindi naman magbababa ng conditions sa'yo na dapat mong sundin na hindi makakatulong sa'yo. So, ibig sabihin dyan, under ka ng monitoring, ng supervision ng probation officer, and then, yung conditions naman, again, na ibababa sa'yo ni court, nakabase naman yan dun sa background mo, dun sa kakayahan mo, and then sa status mo. Kung ikaw man ay mas dapat tutukan sa gantong parte mo, dun magpo-focus yung conditions ng court na ibababa sa'yo. And then, mas mabibigyan ka ng higher opportunity na mabago mo yung sarili mo kaysa ma-expose ka nga dun sa mga kriminal, kapwa mo kriminal na pwedeng magpalala sa'yo or dun sa kalagayan mo kasi mas mahahawa ka. Again, the probation implies that during the period time fixed by the court, so kung ikaw man ay mabigyan ng probation period up to 2 years, so the defendant is provided with individualized community-based treatment, diba? Including conditions he is required by the court. So, he is required by the court. So, pag hindi na sinunod, pag hindi niya sinunod, ibig sabihin, malaki yung possibility na ma-terminate or ma-revoke yung privilege na binigay sa kanya na siya is mag-serve ng kanyang sentence outside the prison or jail. Again, dahil required by the court, kailangan niya sumunod sa conditions na yon. Next, he is placed under the actual supervision and visitation of a probation officer. So, upon the conditions na na-impose sa kanya, Of course, hindi naman siya magsasarili na lang. Meron siyang probation officer na magsusupervise sa kanya, and then meron siyang monitoring or visitation na mangyayari para ma-monitor yung status mo, ma-monitor kung ikaw ba ay sumusunod sa conditions na inimpose ni court sa'yo. Next, under pa rin ang concept of probation, if the defendant violates any of the conditions of his probation, the court may revoke his probation and order him to serve the sentence originally imposed. Ito yung binabanggit ko kanina. If ever magkaroon ng pagkakataon na na-violate ni probationer yung conditions na nilatag sa kanya ni court, o anumang mga bagay na na-violate niya na nakapaloob sa conditions na yon, yung kanyang probation is mare-revoke, di ba? And then siya is ibabalik sa kulungan at kailangan niyang iserve yung kanyang original sentence na na-impose sa kanya nung siya ay nabigyan ng final judgment and sentence. So yun lang yun. Hindi porket nabigyan ka ng pagkakataon na makalaya at nabigyan ka ng probation, di ba? Sabi nga natin, privilege yan at pwedeng mabawi sa'yo kung hindi ka susunod. Next, kabaliktaran naman, if the probationer fulfills the condition na impose sa kanya, he shall be discharged by the court after the period of probation. Again, pag-uusapan naman natin yan kung gaano kahaba yung period of probation sa mga susunod na topic. So, and whereupon the case against him shall be deemed terminated. So now, kapag na-fulfill naman yung kanyang duty, sumunod siya ng maayos dun sa conditions that imposed by the court, so pasok or kaya natapos niya yung period of probation niya, so siya is madi-discharge na. And then, he shall be discharged by the court, and then whereupon the case against him shall be deemed terminated. So, mate-terminate again yung case against him. Lastly, his final discharge shall operate to restore to him all civil rights lost or suspended. Alam naman natin yan na once na ikaw ay napatawan ng sentensya, natawag na convicted offender, napatunayan na ikaw ay nagkasala, meron kang mga civil rights na mawawala or masususpend. So, once na ikaw ay na-discharge na, so meaning to say, natapos mo ng maayos sa probation period mo, mara-restore ang iyong civil rights or yung nawala or yung nasuspend na mga civil rights mo na as a result of your conviction, kaya yan ay nawala sa'yo. Okay, so all in all, sa ating concept of probation, the legal or the basic legal concept of probation in this degree or dun sa PD 968 na sinabi natin are merong twofold na tinatawag. First is, probation is a conditional suspension of the execution of sentence. Yung kanina lang sinabi natin. It denotes that the court assumes a primary role because a grant of probation is judicially dispensed and controlled. Again, si court daw, 'di ba, yung merong or the court assumes the primary role kasi una sa lahat, siya yung nagbibigay ng sentence, and pangalawa sa lahat, siya yung nag-grant ng probation. Okay, pangalawa, ang probation program or yung proper, iyan ay nagpo-provide ng personal care or treatment, and then of course, yung paulit-ulit kanina, the supervision is given through the probation officer. So, it indicates the administrative aspect of probation. So, it is on the part of the administrative body na kung saan hindi na si court yung naggagawa ng gantong bagay. Though, ang administrative body na tinutukoy natin or is under the Department of Justice, so merong bukod na agency which is the PPA or the Parole and Probation Administration na madidiscuss natin sa susunod, na sila yung nangangalaga or sila yung nagsusupervise sa ating mga convicted offenders na nabigyan ng probation. So, ang ibig sabihin lang nito, the personal care up to the supervision ng ating mga probationer, yan ay nasa pangangalaga na ng administrative body or sabi nga rito, it indicates the administrative aspect na ng probation natin. Sa pamamagitan ng supervision, di ba, of the probation officer and from the point of view ng mga social workers natin and social casework treatment na meron tayo. Again, conditional suspension of the execution of the sentence, and it is a personal care or treatment and supervision over the probationer. Next, the probation as a court function. O yung probation is a court function daw. So, the court assumes a dual role kapag ang pinag-usapan natin is the probation. Again, may dalawang role si court sa sa program or dun sa probation law na sinasabi natin. Ang una, of course, is the determination of his guilt o yung determination ng guilt ng defendant. Diba? The court would convict and sentence the said offender. Kasi nga sabi natin kanina, ang nabibigyan lang ng probation are those convicted offenders. Ibig sabihin, ang pwede lang maka-enjoy ng privilege under ng probation programs is yung tapos ng mag-undergo ng trial and nabigyan na ng huling judgment or na-convict na and nabigyan na ng sentence. So, again, on the part of the court, as one of his role, siya of course is yung nagde-determine ng kanyang guilt. So, siya yung nagbibigay ng sentensya at siya yung nagbibigay ng final judgment. Pangalawang role ni court is when the court determines whether or not to grant probation upon application of the offender. Okay, nagawa na ni court yung unang trabaho niya, which is the i-convict niya and then masentensyahan niya yung offender. O now, dahil convicted na yung offender, pwede na siyang, di ba, pwede na siyang maging subject for the application or dun sa grant, ng probation. Once na siya ay nag-apply. So, once na nag-apply, or upon the application of the offender, ang court, ang trabaho naman niya ngayon is i-determine niya kung i-grant niya ba or hindi yung probation. So, it is on the discretion of the court as well as to the qualifications na kanyang i-check. And upon to the investigation, yung mamaya madidiscuss ko sa inyo rin. Basta in short, ang korte po yung nagde-determine kung dapat bang bigyan ng probation or ma-deny yung probation or yung grant ng probation sa isang aplikante or upon the application of the offender, of the convicted offender. Again, ang dual role ni court is to determine his guilt, mabigyan ng sentence, and then after mabigyan ng sentence, qualified or not, siya yung mag-grant or magde-deny nung kanyang petition for probation. Okay, next. The decree or yung PD 968 pa rin yung pinag-uusapan natin, the law, defines, iba nga yung under ng section 3 ng law, the definition of the probation, again, a condition or disposition under which the defendant, after conviction and sentence, is released subject to the conditions imposed by the court and to the supervision of a probation officer. So, ano yung pinag-uusapan natin dito? Basahin natin. It is evident from this provision that an offender will be released on probation only after conviction and sentence. So, no one will be placed under probation kung hindi pa naman siya nabibigyan ng sentence and hindi pa nabibigyan ng final judgment. Yun ang tinutukoy dyan. So, in short, ikaw ay mabibigyan ng probation or ikaw ay pwede lang mag-apply for probation once na ikaw ay nabigyan na ng sentence and final judgment. No one or no convicted offenders will be placed on probation not unless siya ay nabigyan na ng sentensya and then nabigyan na ng final judgment. Furthermore, dun sa section 4, underlines that the necessity of filing an application with the trial court before the suspension of the execution of the court's judgment. So, di ba dapat, di ba yung nakalagay sa definition niya, after conviction and sentence, tapos ang nakalagay is release agad. But, take note that hindi naman porket nabigyan na ng sentence, na convict na siya, i-release agad siya, di ba? Sabi dito, there is a necessity of filing an application bago pa niya mabigyan ng suspension of the execution of the court's judgment. Again, there is a necessity to file an application for probation. Hindi nga yan right na ibibigay sa'yo once na ikaw ay qualified. Yan po ay privilege na ibinibigay dun sa mga convicted offenders na pasok dun sa qualification para ma-enjoy or mag-undergo ng program such as this kind of program, which is the probation program or the probation law. Again, necessity of filing. Nag-a-apply po o nagpe-petition for probation. Hindi porket nabigyan na ng sentence, na-convict na, i-release agad-agad. So, meron pa yung pag-aaral sa korte dahil ang korte din nagbibigay or nag-grant or nagde-deny ng application for probation. Okay, under pa rin ng probation as a court function, or the probation is a court function wherein, next, the petition for probation may be filed by a petitioner directly with the trial court which exercises jurisdiction over his case. Again, yung petition or yung application for probation may be filed directly o yung personally, ikaw yung mag-apply or mag-petition saan? Dun sa trial court na kung saan yun yung may jurisdiction over your case o dun tinry and hinir yung iyong case kung saan nag-undergo ng trial. Diba? Dun ka mag-ask or dun ka mag-a-apply, dun ka magpe-petition for your probation. Again, the petition for probation may be filed directly by the petitioner saan? Dun sa trial court which exercises jurisdiction over his case. So now, if the court, diba, sabi ang court yung merong kakayahan to grant and to deny kasi nga sa kanya nag-a-apply. So now, if the court finds that the petition o yung application niya is in due form o kaya naman, his application is presented in a correct way or manner and he is not disqualified from the grant of probation, si court, he shall now then refer the same to yung kanyang petition, i-refer niya dun sa provincial or city probation officer to. Anong gagawin ngayon? Anong part ngayon ni provincial or city probation officer? Ang gagawin niya is magko-conduct ng post-sentence investigation. Sino yung iimbestagahan? Si petitioner. Yan yung binabanggit ko kanina. Ano ba yung purpose ng post-sentence investigation? So, madidiscuss din natin yan mamaya. Generally, ang purpose niyan is to assess if the offenders does not fail under any of the disqualification na meron dapat. The disqualification na meron under ng probation law. As well as dun eto kasing post-sentence investigation, ito po yung sinasabi nating parang pinaka-short, complete background check mo. Background check nung petitioner o nung aplikante o yung gustong mag-apply for probation. The purpose of the conduct of post-sentence investigation is malaman if he does not fail under any of the disqualification as well as to assess or kaya naman to conduct a short, complete background check ng aplikante or ni petitioner kung papasok ba siya at papasa ba siya dun sa grant or the denial of the probation as well as to para ma-assess na rin kung ano bang klaseng program yung dapat ibaba sa'yo kasi upon the checking or dun sa investigation, malalaman din ngayon ni probation officer kung ano yung best interest mo and as well as the community kung saan ka mailalagay para mas mapabuti or para mas madali yung iyong reformation. So that is one of the function of the court, as well as dun sa nabanggit na nga natin dito, na kung ano ba yung participation talaga ni probation officer aside from the supervision sa'yo once na ikaw ay nabigyan na ng probation. So, ito siya. Siya din ay nagko-conduct pala ng post-sentence investigation. Next. The post-sentence investigation is an indispensable requisite to a grant of probation. The probation law provides no person shall be placed on probation except upon prior investigation by the probation officer and a determination by the court that the ends of justice and the best interest of the public as well as the defendant will be served thereby. Ano bang ibig sabihin nito? Yung post-sentence investigation daw is an indispensable requisite. So, meaning to say, it is absolutely necessary para mabigyan ng probation ang petitioner o yung aplikante, kailangan si PSI or si post-sentence investigation. So, kapag walang post-sentence investigation, ibig sabihin lang yan, walang probation na mangyayari. Diba? No person shall be placed on probation except upon prior investigation. Yung tinutukoy natin na post-sentence investigation. So, again, ano bang meron sa PSI na yan? It is the finding inquiry into all information na tungkol dun sa petitioner. Diba? Ano ba yung mga information that is relative to the character, the antecedents, o yung past niya na criminal records, diba? Or convictions, and the environment niya, kung saan siya galing, yung family niya, ano ba yung mental and physical condition niya ngayon, na pwede mong matutukan or pwede mong maging basihan kung ano ba yung possible na mailatag ni court na probation program para sa'yo. So again, walang probation na mangyayari kung hindi mangyayari yung post-sentence investigation. So, yun lang yung ibig sabihin nun. Next. Post-sentence investigation, sabi nga natin kanina, yan po ay ginagawa ni probation officer. So, ano mangyayari? The probation officer shall submit to the court the investigation report. So, once na tapos na siya sa kanyang PSI or post-sentence investigation, ibabalik lang niya yun kay court or for subject for review, di ba? Not later than 60 days. So, meaning to say, meron siyang 60 days si probation officer to conduct the PSI. Again, not later than 60 days from the receipt of the order of the said court to conduct the investigation. So, upon the receipt of the order, so, dun pa lang mag-start yung count ng 60 days. So, within 60 days or not later than 60 days, kailangan niyang makonduct si PSI. Sinong gagawa ng post-sentence investigation? Si probation officer. Again, next. The purpose of the report is to assist the court in determining whether or not the ends of justice and the best interest of the public as well as of the defendant will be served thereby. So, ang magiging purpose naman or isa sa sense na kung bakit kailangan ng PSI aside from malaman ba kung qualified yung aplikante natin for probation is para ma-assist din yung court para ma-determine kung ano ba yung best para sa community, kung saan siya ibabalik, as well as dun ano ba yung best conditions na pwede nating i-impose kay probationer na makakatulong sa kanya para ma-rehabilitate and ma-reform while under probation program. So, yan po yun. Okay, next. Probation is a privilege. Sabi ko nga sa inyo, it is a matter of privilege, hindi po right. And as such, its grant rests solely upon the discretion of the court. So, nabanggit ko na din kanina. So, dahil nga ito ay hindi right, ito ay privilege, kailangan pag-aralan kung sino ba yung dapat ma-enjoy yung gantong klaseng privilege. Sino ba yung qualified for this such kind of privilege na na pwede kang mamuhay outside the prison while serving your sentence. So, again, yung grant or denial ng probation is solely dependent on the discretion of the court. Next, the grant of probation results in the release of the petitioner subject to the terms and conditions imposed by the court and to the supervision of the probation officer. So, ito na yon. The grant of probation, once na nag-grant na ng probation si probationer, ibig sabihin pasado kay court, ang result niyan is, sabi nga natin kanina, ano bang purpose ni probation? Marirelease na si petitioner but subject to the terms and conditions na kailangan yung sundin na imposed by the court and subject to the supervision of the probation officer. So, ganun yung takbo niya. Kung aalalahanin nyo lang naman din, yung kanyang definition, doon na nakapaloob lahat kung paano ba tatakbo si probation. Diba? A disposition under which a defendant, pagkatapos ma-convict and then magbigyan ng sentence, mapapalaya, diba? Subject to the conditions and terms imposed by the court and subject to the supervision of the probation officer. Next, once the court has granted probation to an offender and has duly imposed the terms and conditions of the probation, the probation officer has the bounden duty to see to it that the probationer observes all the terms and conditions imposed by the court. So, probation supervision is then primarily administrative or an administrative process o yung binabanggit natin kanina na once natapos na yung duty ni court to grant and to, or at least ma-deny yung petition ng isang aplikante for probation, part na ng administrative body which is the PPA through the probation officer yung magiging proseso natin. Diba? Ang pinag-uusapan na natin dito kanina is probation, wherein the probation is an administrative process naman. Yung kanina, probation is a court function. So, natapos na, nabigyan niya ng sentence, diba? Na-convict si criminal, and then siya yung nag-grant, siya yung nag-deny kay probation. Now, yung job niya, natapos na sa ngayon doon. Sa ngayon lang. Hindi ibig sabihin na tapos na siyang mag-grant, wala na siyang part kay probationer. So, no. Papasok lang si administrative body or yung administrative process na kung saan ang trabaho lang naman is the supervision ng probation office ng probation officer kay probationer kung siya ba ay sumusunod sa terms and condition of the probation. So again, yan po is sa pangangalaga ni probation officer. Ino-observe niya kung sumusunod ba si probationer sa lahat ng terms and condition na inimpose ni court. And then there is the start of the administrative part or function of the parole and probation administration through the probation officer na tinatawag natin. Okay, as part of the administrative process nga na sinasabi natin, ano ba yung primary purpose of probation supervision? Bakit ba kailangan pang mag-make supervise kay probationer? Ano ba yung trabaho ni probation officer? First is to carry out the conditions set forth in the probation order. Yun lang kanina, hinihimay-himay lang natin. Yung probation order, yan na mismo yung, nandyan na mismo yung terms and condition na dapat sundin ni probationer. Pangalawa, to ascertain whether the probationer is following said condition. So, dahil nga si probation officer yung nagbo-monitor, siya yung nagsusupervise, diba? As part of the administrative process or as part of the job of the probation officer is i-check or to monitor if the probationer is following the said conditions. Yun lang naman. Maglatag or to carry out the condition na galing kay court or yung probation order. Pangalawa, dahil nga merong nilatag na conditions, babantayan niya or i-monitor niya, ay susupervise niya si probationer kung sinusunod ba niya yung mga conditions na yon. Pangatlo, to bring about the rehabilitation of the probationer and his reintegration in the community. Again, the primary purpose or one of the primary purpose of probation supervision, kung bakit meron tayong probation supervision, is to bring about the rehabilitation of the probation and his reintegration into community. Kung walang supervision na mangyayari, di ba, parang mo na totally pinalaya yung tao na wala kang gagawing grounds para siya ay mahawakan pa or kaya naman mabantayan pa, di ba? Kung hindi mo siya tututukan, kung hindi mo siya isusupervise, kung hindi mo siya i-monitor, yung probation order o yung conditions and terms ng under ng probation order, kung hindi niya yan nasusunod, walang kwenta yung rehabilitation program na nalatag ni korte para sa kanya. Kasi nga naman, hindi naman porket may probation order, merong terms and condition, hindi yun para ma-restrict lang siya basta-basta sa kanya ding mga pwedeng magawa, di ba? Kasi marami tayong conditions na pwedeng ipagawa sa kanya. Minsan, meron dong restrictions, meron dong kailangan mong gawin, di ba? Kung hindi yun masusunod, walang kwenta yung reformation na pwedeng ibigay sa'yo through the community-based process or program. Yung rehabilitation, yung reformation, through the orders or terms and conditions, kung masusunod mo lang sana yun, possible na ma-reform ka. Possible na ma-rehabilitate ka. So, once na may probation supervision, masusunod syempre. Mas kikilos si probationer para masunod din niya yung nakapaloob kay probation order. Diba? And his reintegration into the community. Kung walang magmo-monitor sa kanya sa community, magsusulo na lang yan. Diba? Pera na lang kung yan man ay natatakot pa rin siya na makulong. Pera na lang yan kung siya ay malakas yung loob. Diba? Maalin lang yan. Natatakot makulong ulit. Kaya susunod kahit walang nagbabantay. O kaya naman gagamiting advantage yung kawalan ng supervision sa kanya, hindi na siya susunod, and then possible pa na mag-recommit, makakommit again ng krimen. So kailangan, ito yung tatlong primary purposes ng probation supervision through the probation officer na meron tayo. Okay, to carry out these purposes, yung kaninang binanggit natin na tatlo, the probation law, upon its approval, carried with it the establishment of a probation administration. Ito yung tinutukoy natin kanina. Kung hindi na part ni court, yung pag-supervise kay probationer, kaninong parte? Ano yung administrative process? O sino yung mangangalaga dun sa administrative process na kung saan kailangan nating i-supervise si probationer? Yun po is trabaho ng Probation Administration. It is an agency under the Department of Justice. So, ito yung pinapatungkulan natin kanina. Hindi porket iba na yung mangangalaga kay probationer habang siya is sumusunod sa conditions that is imposed by the court, is wala nang parte si court. So, no, kasi si Probation Administration na yun, under pa rin siya ni DOJ, na kung saan wherein kailangan mag-report si probation administration through the probation officer, kanino ba siya magre-report? Kay DOJ lang din or kay court na kung saan siya yung may jurisdiction o yung may hawak ng jurisdiction dun sa probationer. Next, ano ba yung trabaho ni probation administration? Which shall exercise general supervision over all probationers. Again, ang trabaho naman ngayon ni probation administration, sabi nga natin kanina, siya na yung mag-supervise over all probationers. Lahat ng nabigyan ng probation ni DOJ through the court, diba? Ang probation administration, which is under the DOJ din, siya yung nangangalaga at nagsusupervise ng lahat ng nabigyan ng probation. So, yun siya. At yung pong probation administration na tinatawag natin is the parole and probation administration. So, pag-aaralan pa natin yan sa mga susunod na topic. So, si parole and probation administration. Saan galing sa probation administration? Saan galing si probation officer? Under po ng itong administration na to. Sa pangangalaga nila, sila yung nagbabantay, sila yung supervise sa lahat ng magbibigyan ng probation. Okay, ito nga yung sinasabi natin kanina. At this juncture, it is to be emphasized that in spite of the fact that the Probation Administration is an executive agency, control of the courts over the probationer is not lost. Ito yung pinapaulit-ulit ko kanina, hindi porket nandun na siya dun sa part ng yung supervision is nakaatang na sa probation administration, is wala ng parte yung court upon the or over the probationer. So, hindi po. So, the probationer and his probation officer shall be under the control of the court who placed him on probation in the first place. So, both the probationer and the probation officer, siya po is kontrolado parehas ng court. So, the probationer and his probation program shall be under the control nga ng court who placed him on probation, subject to the actual supervision and visitation of the probation officer. Okay, next, the philosophy of probation. So, marami tayong philosophy of probation wherein ito po is some of the theoretical basis of this probation that we have. So, marami po tayong, again, napag-uusapan patungkol sa philosophy of probation. First, there is no single cause for delinquent behavior. When we say delinquent behavior, di ba, yan yung conduct or yung behavior ng tao that does not conform to the legal or the moral standard of the society. Kumbaga, salungat sa society. Sabi dyan, there is no single cause. Hindi naman lang isa yung reason why merong delinquent behavior yung isang tao. Human beings are extremely complicated. So, no need to explain. Alam naman natin yan. It is not possible to trace complex pattern of human behavior to any single cause. Again, it is not possible. Mahirap matrace yung isang pattern of human behavior to any single cause. So, ibig sabihin, being human, which is extremely complicated, same as with, kung i-connect natin siya dun sa delinquent behavior na meron tayo, it is difficult to trace, di ba, yung pattern, yung takbo, di ba, yung pag-iisip ng tao, kahit sabihin natin marami tayong theories na nagtutukoy kung bakit ba nagiging kriminal yung isang tao, di ba, hindi ibig sabihin no, na ganun din kadali natin sabihin na porket maraming kriminal na tulad-tulad lang yung krimen na ginawa nila, hindi porket tulad-tulad lang yung krimen na ginawa nila, tulad-tulad lang din yung mga factors na nagtulak sa kanila para gawin yung bagay na yon. Same as with the on the application dun sa probation, kaya naman tayo merong individualized treatment. Kasi nga, hindi yan tulad-tulad ng reason, hindi yan tulad-tulad ng approach dapat na binibigay ng institutional correction na yung mass treatment na sinasabi natin. Not unlike sa community-based correction, mas individualized yung treatment, mas nabibigyang focus natin, di ba? Kung ano yung pangangailangan ng tao, kung bakit ba siya nakakommit ng ganitong crime, di ba? Kung bakit nandun siya sa kalalagayan na yon. At mas mabibigyang focus natin o mabibigyan natin ng atensyon kung ano ba yung dapat na programs na ilatag sa kanya. So, next. Delinquent and criminal acts are symptoms. Sintomas ng ano, di ba? The offender against our law is exhibiting a symptom of social or psychological disturbance. So, marami naman tayong theories again dyan with regards to that na yung criminal acts natin is a series of, di ba, yung psychological, mental, physical, di ba, lahat na ng reason or theories why nakakakommit ng criminal act yung isang tao. Di ba, katulad lang yan ng headache, di ba? Just as a headache is a symptom naman ng physical disturbance. Kung meron tayong nagawa or kung yung mga tao, yung criminal ay may delinquent act or criminal act, yun daw is indication na meron daw social or psychological disturbance na nararanasan yung tao. And this means that the juvenile delinquent or adult offender is need of treatment. So, kailangan ng treatment. And the job of the probation administration is to find out what the problems are beneath the symptom and to recommend appropriate treatment plan. So, yun yung kaduktong nung kanina, di ba? So, now, dahil under ng probation administration through the court, malalaman nila, di ba, dun sa kinonduct ng investigation, kung ano ba yung mas recommended na appropriate treatment plans and programs o yung order, di ba? Through the probation order, the terms and condition na dapat niyang sundin na makatutulong sa kanya for his treatment para makatulong for the reformation and rehabilitation of the probationer. Next, that the individual has the ability to change and modify his antisocial behavior with the right kind of help. So, ano bang tinutukoy natin dito? With the right kind of help. On the part of the probation program, diba, sa philosophy ng probation, pinaglalaban kasi nila dito that it is better to treat the convicted offender outside the institution. Diba? Sabi dyan that the individual has the ability to change and modify his antisocial behavior with the right kind of help. At ang pinaglalaban nga nila dito is yung klase ng tulong na binibigay natin under ng probation program is by giving the opportunity, the second chance na mamuhay outside the correction pillar, outside the prison, habang siya is nire-reform, habang siya is nire-rehabilitate, while habang siya is sumusunod dun sa conditions na inimpose ni court, di ba? Aside from the right kind of help, di ba? Mas hindi makakatulong again yung pag-expose mo kay first time offender, kay offender na possible na hindi naman niya totally talaga gusto yung kanyang ginawa, di ba? Hindi naman totally yung mind niya is criminal. I-expose mo pa dun sa mga criminal na the hardened criminal, ano mangyayari? Magandang tulong ba yung pagkulong sa kanya doon or not? So, yun po yung isa sa stand or dun sa philosophy ng probation na by receiving the right kind of help, mas matutulungan natin yung individual or yung probationer. Next, the central goal of probation administration is to enhance the safety of the community by reducing the incidence of criminal acts by person previously convicted. Kasi sabi nga natin kanina, once na nasa community siya, di ba, andun na yung chance niya na mamuhay ng normal. At sa tingin ba natin, mas gagawa ba siya ng ikakasama pa niya, di ba? So, mas malaki yung ating assurance, di ba, na siya is magiging law-abiding citizens. Kasi nga, Kasi nga, aside from the probation officer na nakamata sa kanya, nandun din siya sa community na mismong dun siya sa community na kung saan possible na mahusgahan siya or naguhusgahan na siya mismo dun dahil sa krimen na nagawa niya. So, the goal is to achieve through counseling, diba? Kasama naman yan sa probation program. The guidance, the assistance, the surveillance, and the restraint of the offender to enable their reintegration into community as a law-abiding and productive member. So, yan naman ay nakapaloob naman yan sa probation program na kung saan makakatulong, diba, sa ating probationer para hindi, lalo nang maiwasan niya yung makapag-commit ulit or ma-reoffend ulit yung community dun sa kanyang criminal behavior na nagawa or yung sa kanyang criminal acts. Okay, it is generally conceived that the probation as a matter of privilege to be granted refused at discretion of the state. The applicant has already been convicted and sentenced by the court, and it is also, it is only the mercy of that he may be given probation. So, ito lang yung nabanggit na kanina. A probation is a matter of right that is granted or maybe denied by the court, and dapat bago ka mabigyan ng probation, the applicant dapat siya is already been convicted and sentenced by the court, and it is solely dependent or it is only dependent on the mercy of that he may be given probation. And aside from that mercy, kasi nga privileged lang siya, syempre dapat pasok ka dun sa qualifications na pwedeng mabigyan ng probation at upon the assessment or the investigation, makita ni court through the report o dun sa PSIR or the post-sentence investigation report na ginawa ni probation officer na mas magbe-benefit ka as well as the community kung ang probation I mean the correction program na gawin sa'yo is outside or inside the institution. So, depende pa rin yun, again, dun sa discretion ni court kung saan ka babaksak for the denial or for the approval of your petition for probation. Okay, next. No violation of probation conditions should result in automatic revocation. So, meaning to say, walang revocation na mangyayari kung walang violation na mangyayari. So, yun lang po yun. The last is, no physical would undertake to prescribe treatment for a sick man unless he has report of his ailment and condition or yung diagnosis na nangyari. Hindi mo magagamot yung isang tao kung wala kang diagnosis kung ano ba yung kanyang sakit. Hindi mo siya mabibigyan ng proper treatment kung hindi mo alam yung kanyang sakit. So, a judge should not pass judgment on a man without post-sentence investigation report. For the last philosophy, ang ibig sabihin lang dito, hindi ka pwedeng mag-grant, hindi ka pwedeng mag-deny agad-agad ng petition for probation without the post-sentence investigation report. Kasi nga sabi natin kanina, it is indispensable requisite or it is absolutely necessary para mag-conduct ng post-sentence investigation bago tayo mag-grant or bago mag-deny ng court ng probation petition si court. So that is the last for the philosophy of probation. The elements and characteristics of probation. So first, what are the 4 essential elements of probation? So, mauulit lang natin yung napasadahan natin kanina. A post-sentence investigation report or the PSIR, which will serve as the informational for the court's decision to grant or deny probation. So, kailangan ng PSIR para mag-grant or mag-deny ng probation si court. Next, the conditional suspension of execution of sentence by the court. So, once na nag-grant, automatic magkakaroon ng conditional suspension of the execution of sentence. So, sa halip na ikulong, suspended si execution ng sentence and then lalaya siya under the condition imposed by the court. At yun yung pangatlo. Condition of probation imposed by the court to protect the public safety and to transfer the rehabilitation and reformation of the probationer. Lastly is the supervision, kailangan yan, the guidance and the assistance of the offender is sa pangunguna po ni probation officer under ng probation administration which is the parole and probation administration na under din naman the Department of Justice na kung saan si court yung nag-grant kay petitioner para magkaroon ng probation. So, yan po yung 4 essential elements. Kailangan ng PSIR. So, i-release siya once na nag-grant. And then, kapag na-release, subject to the condition imposed by the court. And then, babantayan ni probation officer. Next, essential elements of the probation system under the PD 968. So, mapapag-aralan pa naman natin yung, ng malawak yung PD 968. So, essential elements again, the probation is a single or one-time affair. So, ibig sabihin, isang beses mo lang siya ma-enjoy. Once na ikaw ay under na ng probation, ikaw ay nag-commit ulit, hindi ka na pwedeng mag-apply or mag-petition for probation. Next, probation system is highly selective. Why highly selective? Aside from the PSI na ginagawa yung investigation, aside from the qualifications na kailangang ma-meet, nakadepende pa rin siya sa discretion ni court kung ano ba yung mas makakabuti kay convicted offender, as well as to the best interest ng public. Hindi porket pasok ka sa qualification pero ikaw naman ay banta, kapag nakalabas ka ng kulungan, mas pipiliin ni court na mas makulong ka na lang kesa bigyan ka ng probation, kesa makasama ka palalo sa labas ng kulungan. Kasi nga, probation is a matter of privilege, hindi po yan right. So, wala kang karapatang magreklamo kung hindi ka mabigyan ng probation. Next, persons under probation retain their civil rights, yung kanina nga, like the right to vote, or practice one's profession, or exercise parental or marital authority kapag siya is under ng probation, lalo na kapag natapos na yung kanyang probation period. And then lastly, characteristic of probation, which is napasadahan na natin kanina, more enlightened and humane correctional treatment, di ba? Si probation daw, mas more enlightened. Yung sabi nga natin kanina, mas may direksyon yung buhay niya. Kasi aside from the magsisikap siya habang nasa labas, may nakalatag sa kanyang program na makakatulong sa kanya para ma-rehabilitate. Kung susundin niya yon, mas lilinaw yung direksyon niya sa buhay. Diba? And ang probation daw is humane. Diba? Mas makatao. Sa halip na ikulong ka sa kulungan, diba? Na-deprive ka ng liberty mo, ng freedom mo, may kalayaan ka sa labas. But subject to the condition imposed by the court. Next, it aims to promote the reformation of the offenders. So, no need to explain that. Kahit naman yan ay non-insti or insti, ang focus naman nila is ma-reform si offender. Next is to reduce the incidence of recidivism. Na-discuss natin kanina. Yung paulit-ulit na pag-commit niya ng crime, diba? Mas maiiwasan natin yun kung siya is under ng probation program. Kasi, iiwasan niyang makapag-commit ng crime. Kasi possible na makabalik siya sa kulungan at ibabalik talaga siya sa kulungan kapag na-violate niya yung conditions that is imposed by the court na dapat niyang sundin. Next, it extends to offenders individualized and community-based treatment programs instead of imprisoning them. Instead na makareceive sila ng mass treatment inside the prison or jail, provided under ng probation program na meron silang individualized treatment. Kung ano yung na-assess ni court, kung ano yung naaral ni court na dapat condition na nasa iyo, ano yung program na mas makakabuti para sa iyo, diba? Individualized treatment. Mas matututukan ka, mas mabibigyan ka mas mabibigyan ka ng mas magandang program para makatulong for your reformation. Next, it is limited to offenders who are likely to respond favorably thereto. Sabi nga natin kanina, hindi naman yan lahat, di ba? Hindi yan karapatan ng lahat ng convicted offenders. Di ba? Limited offenders lang, wherein yung qualified lang yung mabibigyan nito. Last is it is less costly than the confinement of all offenders in prison. Sa halip na ikaw ay kasama sa popondohan ng gobyerno inside the prison, ikaw is nasa labas pa ng community, di ba? Cargo mo yung sarili mo, magiging taxpayer ka pa, di ba? Makakadagdag ka pa sa ipopondo mo. Ipopondo ng gobyerno doon sa kapwa mo kriminal na nasa loob ng kulungan. So, the point is, kabawasan ka sa gastusin ng gobyerno kapag ikaw ay nasa loob ng kulungan. Okay, that is all about the nature of probation in the Philippines.